cases, injuries, and abuse. Across the state of Alabama, the attorneys of Hollis, Wright & Couch are here to serve you. With civil trial lawyer Josh Wright from the firm of Hollis, Wright & Couch and Alabama's 13 host David Lamb, the attorneys answer your tough legal questions straight ahead.
Hello and welcome into the attorneys. Criminal and civil law, different avenues of justice. That is our topic of conversation tonight. But before we get that conversation underway, want to invite you to join the conversation. Several ways for you to do so throughout the program. You will see what you see now, the telephone numbers, the email address. You can also find us on Facebook and Twitter. Plenty of ways for you to join the conversation, so we invite you to do so. We have this panel of experts here so that you can get your legal questions answered. So please join us in this conversation. We're joined by Josh Wright of the firm Hollis, Wright & Couch. Josh, good to see you.
You too. Hope you had a great week.
Indeed did. Our conversation tonight, a lot of confusion many times between criminal and civil law.
Yeah, you know, a lot of times we will do shows that help explain the differences between certain types of areas of the law. This is a great example of that. There are significant differences between the criminal law and our codes and civil law, and we're going to talk a little bit about that today and how people can use those various types of law to their advantage. And when we talk about criminal issues, of course our firm handles a lot of the civil issues, but when we talk about criminal issues, we talk about, you know, bringing on guys like Joe Baskier. Brett Bloomston, who is his partner at Bloomston & Baskier, has been on the show before to talk about criminal issues, so we're glad to have Joe on. We're excited to have you here, and he's going to be able to help us kind of walk our way through this process. Thanks for being on today.
No, thank you for having me.
Can we just kind of start, Joe, with an overview? Just help us with the difference between criminal and civil law.
Sure, and it's a good question. A lot of people have a lot of confusion about this. At the most fundamental, you know, basis of this thing, you're looking at civil law where typically you're going to be dealing with some sort of monetary damages. You're going to have a plaintiff and a defendant, and they're going to be battling over that. Criminal law is much different because it involves the extinguishment of civil liberties and civil rights is really what we're talking about. The potential for jail time, the potential for certain rights to be taken away from you, like the right to vote, for example. So it's much more serious, and that's why you have a higher burden, a higher standard attached to a criminal case versus a civil case.
And in terms of examples, I guess if a crime is committed, that's going to be criminal.
Correct.
Right? But if it's a property dispute, something like that, that's more civil?
Correct. That's right. Sometimes, obviously, the two can intertwine.
Yeah, sure.
And I guess the classic example would be an accident involving a drunk driver. Okay? In that situation, the drunk driver would be arrested and prosecuted for driving under the influence, a DUI. But then there would be a separate civil action involving the damages that occurred due to the accident.
And we deal with that a lot, and we can talk throughout the show about kind of the implications of how the result in the criminal case can be advantageous to the result in the civil case. Joe had talked generally about the differences, and he also mentioned the burden differences. The burden of proof is kind of an important concept that we want to talk about today, and Joe and I can kind of work through it, but the short of it is this. You have various burdens that you have to prove, David, in order to be successful in a court of law. For example, in a civil case, the burden is called the preponderance of the evidence, or more probable than not, more likely than not. Some lawyers call it 51%. If you have the scales of justice starting even in a civil case, a lawyer has to fill the scale with a little more evidence on one side than the other. So if you fill that scale ever so slightly and you tip the scales of justice, you've met what's called the preponderance of the evidence, and the jury is responsible for returning a verdict in the case. So it is a lower standard than that of the criminal standard, which is beyond a reasonable doubt. Joe, I'll let you kind of tackle what that means.
Sure. I mean, first of all, it's important to know that beyond a reasonable doubt is the highest standard we have in our system of criminal justice or the court system in America. I've watched a couple of attorneys use this example in jury selection and trial, and I think it's a good one. Look at O.J. Simpson. Okay, he has a criminal trial. He goes through that jury trial process, and he's found not guilty. The jury found that the state failed to prove his guilt beyond a reasonable doubt. And what happens next? The victim's families come and sue him civilly. and he lost. He lost in that civil proceeding because they were able to meet that burden of beyond a preponderance of the evidence.
Right. Yeah. What are the penalties under the criminal system?
Well, it really depends. Okay, I mean, typically you have 3 different avenues that you might have to deal with in criminal law. One would be, at least in Alabama, the municipal court system, which is going to deal with misdemeanors. Okay, you have the state county level, which is going to deal with some misdemeanors and felonies, and then of course you have the federal system. And the penalties are going to be all different depending on where you fall. But a misdemeanor is typically going to involve a maximum penalty of 12 months in jail. Okay. A felony starts a day beyond that in Alabama, a year and a day and beyond in terms of potential imprisonment. Okay. Okay. The sentencing issues in federal court are a lot more complex, but typically you're dealing with felonies in federal court. Okay.
Let's kind of, again, to take it just back to the base. If someone is arrested, let's kind of start there. If something happens and there's an arrest take place, kind of what happens next? Take us from that point.
Sure. You're generally going to be arrested. Well, if you're dealing with, for example, our DUI example, you're going to be arrested at the scene of the crime. Right. There's going to be an officer that's there because of either an accident occurred or because he was observing the person driving and thought they might be intoxicated. They'd be arrested at the scene, put in handcuffs, brought to a jail. Actually, state law requires that they be held for a certain period of time in a DUI situation because they have to be ensured that they're not intoxicated when they're released, but they'll have to make a bond. Okay. If you're dealing with a felony situation, that can occur as far as arrest goes in a number of different ways, but the process is the same. You're arrested, you're brought to jail, and you have to make a bond. A lot of people have questions, at least in our experience, about the bonding process.
It is kind of confusing.
And it's scary for people that haven't been through that before. But there are 3 basic ways to handle bonding. The first is you could put up a cash bond. If you're looking at a misdemeanor, your bond's going to be anywhere from $500 to $1,000. If you're looking at a felony, it's going to be anywhere from $3,000 up to $1 million in some situations. You know, when a bond is lower, you sometimes see people put up just the cash amount for the bond. But other good options could be going through a bonding company. A typical bonding company in this area is going to charge 10% of the total bond. So if you have a $10,000 bond on a felony, you need to put up $1,000. Okay. Another option people don't know about, which is a great option, especially if it's a high bond, would be to put up property. If you own a home or land, really preferably in the county where your charges are, you can put that up as surety to ensure that you show up in court.
Joe, and explain just so people understand what the concept of a bond, why you have a bond.
I mean, the bond is there, number one, so that you don't have to remain in jail while you're waiting for your case to unfold. The bond is there to ensure, to satisfy the court that you're going to come back. Whenever your court date is, that you're going to come back to court.
And okay? Sometimes you'll hear, David, bonds, are not allowed. And a judge will not allow a bond.
In some situations, that's correct.
Because of the severity of the crime or the possible risk, flight risk, or?
Those are two situations where you might see a no bond. Another situation might be if you're on probation. Right. And you've been arrested for another crime, they may seek to put you in on a no bond.
Interesting issue here. If you use a bonding company and you're successful in your case, do you get your money back from the bonding company?
No, you don't. You do not.
So there may be implications regardless of whether or not you're innocent.
And if you make a cash bond, a lot of times that money can go to pay court costs and fines, which can get very expensive.
Yeah. All right. Time for our first break, but we're coming back after the break. As we head into break, we'd love to hear from you. Ways for you to get in touch with us. You can call or email your question as well, firm@hollis-wright.com. You'll also find the firm on Facebook and Twitter. At Facebook, you'll find them, just search the term Hollis, Wright & Couch. And on Twitter, it's Hollis_Wright. You'll find them there as well. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis, Wright & Couch, and thanks for watching The Attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other civil legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family. Or simply contact us by going to alabamas13.com and click on the Attorneys link. We know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on Alabama's 13.
Hello and welcome back into The Attorneys. Looking forward to your feedback all throughout the program. You can provide that. Just email or call the numbers that you'll see on your screen, and we'll do our very best to get your questions to our panel of experts. As we were heading to break, we were talking about the whole bonding process. Let's talk for a minute about the civil process and how that actually works.
Yeah, really, the issue that we were discussing is how a criminal case gets started from arrest through the bonding process, and then we'll go into kind of the procedure thereafter. From a civil perspective, it's totally different.
Okay.
And I know it sounds basic, but a lot of individuals who have not been part of our criminal or civil system and have not used the court system may not understand the concept and the differences. So we'll try and do a good job today of explaining that. In civil court, you can either represent yourself, but generally you are represented by an attorney. And the way the process starts is by the filing of a simple complaint.
Okay.
You go into a courthouse in the circuit clerk's office or in the district clerk's office, and you literally file a document that has certain allegations with certain requests for damages. That is then served generally in Alabama through a sheriff. There are a couple other ways for you to serve it. And then it is received by the defendant that you are bringing suit against. And the defendant has a specific period of time to respond to that through an answer or through some form of a motion and motion practice to dismiss the case. And so it's a totally different process from that of what we've talked about from the criminal side on getting arrested, trying to bond yourself out of jail, and then getting started. So I think at least from a civil perspective, that's the start process of how the suit starts. We can talk in a little bit about where it goes from there.
Okay. All right. And Joe, if you would, just kind of walk us through the court system and how that process works.
Sure. And there are major differences between the court process from a criminal perspective versus the civil perspective. The end result, the end product potentially is the same, which would be a jury trial, but how you get there is drastically different. Looking back at our three different avenues, and I'm talking about municipal court, county felony situations, in federal court. In municipal court, you're not entitled to a jury trial. You can either negotiate your case and see if you can get it dismissed or come to a plea agreement with the city, or you can have what's called a bench trial, where the judge makes all the decisions, and if you're found not guilty, great.
Right.
If you're found guilty, then if you want to keep pursuing that, you actually have to appeal that to the county level, where you'll be allowed to have a jury trial. In federal court, from that perspective, the process is actually a little bit simpler. You start off with an arrest and an arraignment. You can negotiate the case there. That's going to center around federal sentencing guidelines, which we really don't have time to get into. And then if you can't do that, then you have a jury trial in federal court, which actually moves very quickly. That process in federal court does. In state court, particularly where we are right now in Jefferson County, the process begins in district court. When you're looking at a felony. In district court is where you're entitled to have a preliminary hearing. A lot of people hear that term. A preliminary hearing is not a trial. It's what's called a probable cause hearing. It's a very low standard. It's simply on the part of the state. They have to show the judge that there's enough evidence to keep the case moving through the system.
Is the point of the preliminary hearing to prevent frivolous or other terms you hear from actually making it to trial?
It's a safety mechanism.
Okay.
That's right. It's a way to weed out cases that don't need to to move on up to the jury trial situation.
And there are times at that stage that a case is dismissed for not having sufficient information,
certainly,
or sufficient evidence to present the case. It generally does not happen, but there are times when it happens, and that's why that process is there.
I think something that's important to note at this point is, I'm a former prosecutor, okay, so I've been on both sides of the boat as far as criminal law goes. People get very confused about how a criminal case is handled. In a civil case, you have a plaintiff and a defendant, two people or two companies or whatever. Mm-hmm. In a criminal case, you have the defendant, and then the plaintiff is actually the state of Alabama. If you have a crime where a victim has been harmed in some way, it's not the victim's case. Right. It's the state of Alabama's case. It's the prosecutor's case. They are the other party. So they really drive the train as far as how that case is going to be handled. Will you just quickly touch on, from a criminal perspective, if somebody cannot afford to represent themselves, there are some mechanisms in place to try and assist, are there not? That's correct. The court can determine your indigency status, and that's a pretty easy process. They can figure out pretty quickly whether or not you can afford an attorney. Right now, in most counties in the state, you would be appointed an attorney, a private attorney to represent you. That's actually changing over the next couple of years, and you're going to see most counties going to a public defender office, actually. So the office essentially would be appointed to represent you, and then you'd be assigned to whatever lawyer they decide to assign you to. One of the interesting things to note, unlike the criminal court system where the crime that you have been arrested of generally will dictate what court system you're going to be in the civil system, the plaintiff is the he's the determiner and kind of the master of his own complaint and can decide where he's going to file, albeit a local municipal courtroom, a district court, a circuit court, or even a federal court. So that is a unique difference between the two different types of law.
All right, a question that we have. I have a trial, a case that's about to go to trial. What should I expect?
That's a big question.
Yeah.
And incidentally, I didn't quite finish up with the procedure in state court. After that preliminary hearing in district court, the case would move to the grand jury, which is a process the defendant's not involved in. That's important. It's kind of a secretive proceeding that just involves the grand jury and the prosecutor, okay? If the grand jury decides to what's called true bill that case, then you're in circuit court, you're ready for your jury trial. Civil and criminal jury trials are drastically different. Criminal trials are really the last area of law where you can see trial by ambush. In civil trials, both parties, and tell me if I'm wrong, but both parties really pretty much know what the evidence is going to be from each side.
That's accurate.
In criminal cases, the state has certain obligations in terms of what they have to turn over to a defendant, but they will follow that to the letter of the law. And that can mean that the defendant's not apprised of all of the evidence, right? Just what's required of the state or the federal government to turn over. Okay. So hopefully by the time you get to a criminal jury trial, you've had a chance to see what their evidence is and absorb that and have a general idea of knowing what's coming. You begin with jury selection. Then you move into the trial phase. You have typically 12 jurors there to sort of decide the case.
Okay.
And in some situations, you may have some alternate jurors just in case if it's going to be a long trial. Importantly, in Alabama, juries do not set the punishment. They are simply there to decide whether or not the state has proven the guilt beyond a reasonable doubt. They do not get involved in the sentencing aspect, except for a capital murder case.
Great differences in civil cases we can get to if we need to go to break.
All right, we'll head to break. We'll discuss that on the other side, though. I want to invite you, one final segment, remaining. You'll be able to get in touch with us. You can email, you can also call, also find the firm of Hollis, Wright & Couch. Just search that term on Facebook or Hollis_Wright on Twitter. Find them there as well. Look forward to your questions. One final segment of The Attorneys coming up after this break.
From all of us at the law firm of Hollis Wright & Couch, we're glad to have you here with us every Sunday night on Alabama's 13. This week we're discussing criminal and civil law, two different avenues for justice. It's important to note the differences between criminal and civil law so that you know what you could face if you ever have to appear in court. The first major difference is in potential jail time. Under the criminal law system, you may be arrested and if convicted, serve jail time. Under the civil system, you're never arrested and will only have to pay monetary damages if a jury finds in favor of the plaintiff. Your insurance company will have to satisfy the verdict. The second major difference is the burden of proof needed. The burden of proof is higher in the criminal system. It's beyond a reasonable doubt. In the civil system, it's proof by a preponderance of the evidence, meaning greater than 50% or more likely right than wrong. And finally, in some cases, the two systems do overlap. For example, if you've ever been seriously injured as a result of being a victim of a crime, you may be able to pursue a claim in the civil system. In that case, after calling the police, you should also consult with an attorney who can evaluate whether or not you have a case. Please remember your call, email, or text to the attorneys is free. All of us at Hollis Wright & Couch want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks again for watching The Attorneys here on Alabama's 13.
Just the facts there on homicides and criminal activity. Welcome back into The Attorneys, our final segment here. Still time for you to get your questions to us, so just get those to us, call or email the information you see there on your screen. As we went to break, talking about the procedure for criminal proceedings, how different is it civil-wise?
Drastically. You know, it is, Joe made a good point that there are circumstances in a criminal context where there can be a trial by ambush where a criminal defense lawyer does not know something's coming and in the middle of trial figures it out.
Okay.
Civil cases, really totally different. Lawyers are detailed enough to go through the civil discovery process through depositions which are under oath, out of court statements that are taken. Discovery proceedings back and forth where you submit requests and questions for the other side to answer and they respond to you. There are very few Matlock moments and Law and Order moments in the civil context where it's an aha, we got you in a civil case. If you've done your job as a civil lawyer, you're never asking a question you don't know the answer to at trial, and there's not a lot of trial by ambush whatsoever. It is very uncommon, for example, in the criminal context for there even to be an out-of-court deposition that is an under-oath deposition. It happens, but it's uncommon, whereas you could have as many as 10 to 40 depositions in a typical civil case, depending on the type of case that you've got. So there are some pretty significant differences between the two proceedings themselves.
Okay, a question that we have, can someone simultaneously be a defendant in the criminal system as well as the civil system?
Good question. Go ahead, Joe.
I mean, certainly, and it happens all the time. Going back to the classic example, in my opinion, would be the drunk driver who's been involved in an accident.
Okay.
But that's just one example.
Assault's a good example.
Assault is a good example. Securities fraud cases are almost always going to involve criminal and civil situations. Sexual assault or rape is a fantastic example. I'm not saying it's a fantastic thing, obviously, but you can have someone being prosecuted for that in a criminal situation, and let's say they were the victim's boss or supervisor, and the assault happened in the employment context. There would certainly be some serious civil ramifications for that, I would think.
Sexual assault is one of the biggest things that we see on the civil side, where the criminal case may be proceeding and the civil case would proceed at the same time. There's also sometimes some work and negotiations between the district attorney and the civil plaintiff lawyer, if you will, to make sure that one case is not harming or hurting the other. Oftentimes, district attorneys want to make sure that the case is prosecuted the way they want to prosecute it, and for good reasons, because they've got a higher burden. Once that case is over, then the civil case is filed. Sometimes they will track together.
Okay. We've got about a minute and a half remaining. Is there time for a final thought, but also just anything we've not covered that maybe you guys would like for us to? And Joe, we'll start with you. Any final thoughts here as we wrap up?
This is what I want to say. Okay, it's very important that people don't think that they can go through this process without an attorney. And I don't say that lightly, but I've seen people try to do that. I've seen people try to act in a pro se manner, and the system has gotten to the point where it's just too complicated to do on your own. You can't. You got to go to experts to watch out for your civil liberties and for your interests. You have to. The stakes are way too high.
Right. Okay.
I think Joe hit on the issue, which are the stakes are very, very high, and you need to have somebody hold your hand, lead, guide, and direct you through the process. The ultimate result may be a jury trial in both systems. One thing to mention that we have not talked about is in Alabama, you've got to have a unanimous jury. So in juries of 12, you've got to have 12 people agree on the innocence or the conviction of an individual. In civil cases, you've got to have 12 people agree on the monetary amount.
All right, gentlemen, we appreciate the time. That's going to do it for this edition of The Attorneys, talking about the differences in the criminal and the civil system. Hope you have enjoyed it. We'd love to hear from you. Still time for you to do so. If you'll call, every call gets some sort of response from the firm of Hollis, Wright & Couch. So even though the program is going off the air, you still have opportunity to get your question in. You can also email the firm. There's the email address, and find them on Facebook and Twitter. Updates of what's coming up. A great way to be in the loop. Find them on Facebook. Search Hollis, Wright & Couch. On Twitter, it's Hollis_Wright. We appreciate you being with us, and we will see you next week.